Hello, thank you for joining our webinar on leases today. I'm going to share my screen so that we can jump right into the PowerPoint presentation. And I can kind of explain with a little bit of help from some slides about some of the benefits and distractions in leases and how to best protect your investment that you're making in your business. All right. All right, so I'll tell you a little bit about myself. I am the current Southeast Board President for the U.S. Pan-Asian American Chamber of Commerce. I am an attorney by profession, but I also volunteer as this position as a president of the Southeast Board. I'm located in Georgia, and I've been practicing about 20 years, mostly in the area of commercial and business-related subjects. So this topic on leases is very near and dear to my heart. Just a brief introduction of the president of the U.S. Pan-Asian Chamber of Commerce, Ms. Susan Allen. She has been running the organization for over 35 years, and she is in Washington, D.C. The regional chapter began in 2014 and has been very instrumental in lots of different industries and areas, helping Pan-Asian American small businesses make that link with larger corporations and government entities so that they too can benefit from the vast amount of contracts and opportunities and services that are needed by the government and larger organizations. All right, well, we're going to get right into our topic today. So one of the main questions I get oftentimes is, can I actually negotiate a lease? So often clients are given a contract, like a lease agreement, and just assume that there's nothing they can do about it, that either they sign it or they lose the opportunity. That's absolutely not true. Most leases can be negotiated. And if they can't, you should consider maybe not even bothering with that landlord and trying to find a different space where you can get what you're looking for. So some of the things that you can definitely negotiate in a lease are the term of the contract, a termination clause, use and exclusivity of that use, assignment provisions, and guarantors. I will go into each one of these along the way so that we can better understand what each of these mean, why they're important, and what parts of them can be negotiated. So the first part is the lease term. So there's a lot of times where a lease will say 10-year term, 15-year term, 20-year term, and those are fine, but a lot of times you have to kind of assess whether or not you have the opportunity to exit at some point. You know, there's always circumstances that come up in your business where you may not want to continue the business, you may want to sell it off, you may want to transition to something else, so you should have the flexibility. So oftentimes, instead of having a very long-term lease, like 10, 15, 20 years, where you don't really know what the market conditions may be after that period of time, it may be easier or better for the tenant to enter into a lease that has shorter terms with options, so that you're in control of whether or not you want to actually move forward to the next smaller term of the lease. For example, instead of a 20-year lease, you may want to have 4, 5-year term leases. And at the end of each term of 5 years, the tenant, you would have the option to then extend it for another 5 years and another 5 years, another 5 years. That gives you complete control, but only if you are able to negotiate the price ahead of time. If you don't negotiate the price ahead of time, then you're going to run into an issue where you may not have control of what the price will be after that 5 years. So if your lease says something like, after 5 years, the landlord and tenant will come up with their own terms or their own lease amount or rental amount based on fair market value or based on the market conditions or some kind of language like that, essentially it means you don't really know what your rental amount is going to be. And that means you don't have a true option. So the only way to really have a real option where you have control to extend the term of the lease is to negotiate what that rental amount will be upfront for each of those option terms. It also reduces your liability because if you had a 20-year lease and your business wasn't doing that great, if you defaulted and stepped out of your business or vacated and just shut your business down, you would technically still be responsible for the entire term of that lease. And so it is much less painful to have a very short lease. So even if you had to default or you couldn't continue your business, you would only be responsible for a much smaller segment of that. Maybe the remnants of whatever was on your 5-year term rather than a 20-year term. There's also something else to consider on renewal provisions. Sometimes they are very specific as to when and how you have to renew the lease. You may only be able to renew it within a certain amount of time. And if you fail to notify the landlord within that time, you could completely lose your rights. I've had several cases where the tenant forgot, at the end of the 5-year term, the landlord said something like in the lease, it said 90 days prior to the expiration of the current term, you must notify the landlord in writing by certified mail that you intend to extend the lease. And if you fail to do that, the landlord has no obligation to extend that lease for you. So be aware of those renewal provisions, put them on your calendar a couple months in advance so you're well aware you have time to draft that notice properly and in accordance with whatever the lease actually says. The other thing to think about on lease terms that's not mentioned on this slide is that when you purchase a business or you're starting a new business, make sure that the lease term is actually long enough for you to be successful in your business. So while we talk about shorter lease terms, sometimes you buy a business and there's only 2 years left on the current lease. You have to assess whether your investment into that business, whether it be you're buying a business or you're starting fresh, is worth you being able to recover that investment within 2 years. Because at the end of the lease term, the landlord has no obligation to extend for you. I mean, worst case, the landlord could just say, well, your lease is over, you need to leave. And so you got to make sure that you have enough time to be successful in your business. So oftentimes 5 years is probably a good start, and then with multiple options to extend that. Another clause in a lease that can be negotiated, although it's not always, it's definitely not in the landlord's interest to get into a termination clause. However, a lot of landlords are willing to enter into some kind of termination clause for a couple of reasons. There is some kind of, they know what to expect in case a tenant can't perform. It also gives a tenant an out in case they are not going to be successful or things have gone south because of personal reasons. But it gives everybody a kind of known damage, if you want to say. So, for example, you could say something like, or ask for something like, in the event the tenant wants to terminate, they would have to provide the landlord maybe 90 days, 120 days notice, and maybe 4 months of additional rent as not a penalty, but as a liquidated damage in order to exit the lease without full, future liability, ongoing future liability. So obviously that reduces the liability of the tenant. It gives you an exit clause in case you ever needed it, and the cost is certain. So you can definitely assess, is it better for me to terminate or is it better for me to continue the business until the end of the term of the lease? Because like we talked about earlier, that the lease term is what you sign up for. If you break it at some point or you default, you're still responsible for all your lease payments all the way through the end. And the landlord is not really obligated to, go full steam ahead and try to find a new tenant to replace you. And even if they are going to find a tenant, there's no guarantee they're going to find one that does exactly what you did or has the same use of the space. They may have to incur more costs to rebuild it or get a broker involved to find a new tenant. And their rent may be less than what you're willing to pay or you had agreed to pay in your lease. And so you would be responsible for all those damages as well. So this kind of a clause kind of protects you and provides you a way to exit with a known cost and a known time frame in which you'd have to make that decision. It also gives the landlord certainty too, to know that, okay, if this person is going to terminate, he's going to give me X amount of notice up front and X amount of money up front, and then I would allow him to terminate, and that gives them a heads up too to try to find a new tenant to fill that space. The next provision is something that is often overlooked. It is about the use of the premises and exclusivity in that use. So there's two parts of this. First part is the use. Don't try to pigeonhole yourself into a very small use of the premises. If you are going to operate a restaurant, it's probably to your detriment to say, I'm only going to sell wings, or I'm only going to sell milkshakes, because as you get into the business, you may find that customers want pizza with those wings, or they want salads, or they want some other type of offering that your business could provide. And you don't want to pigeonhole yourself into just one very, very specific type of offering. So try to keep that as broad as possible. If you're going to be a restaurant, maybe just say for restaurant use only, and try not to pigeonhole yourself into a particular brand either. You know, like I'm only going to operate a Taco Bell here. I'm only going to operate a certain type of pizza chain here, because things could change. Maybe your franchise changes. Maybe they get bought out. Maybe, you know, there's all sorts of things that can adjust over the course of your lease, and you don't want to be limited to just offering that one thing. So the broader, the better, if you can negotiate that. The other thing is, if you have a very specific offering, like let's say you are a Korean barbecue restaurant, maybe you want to ask the landlord to make your offering exclusive within a shopping center or whatever, maybe as the strip mall center or something that the landlord also owns, to make sure that nobody else sells the same kind of thing that you're selling. A common example is like a wings place. Wings is like a very specific type of offering, right, as a food. But maybe the pizza restaurant 3 doors down decides to add wings to their menu, and that could hurt your business. So before you sign that lease, you could ask the landlord to make an exclusive use provision for you to say nobody else in the shopping center can sell what I'm selling if it makes up more than 10% of their business. So that kind of protects you going forward to make sure there's no competition for your particular offering. There's also provisions to say that if the landlord doesn't abide by that, then you would get certain types of relief, like 50% off your rent, or you could take injunctive action to stop the landlord from allowing that to happen in the shopping center. So that's something else that you could definitely negotiate up in front before you sign the lease. The next provision is assignment. Most people, when they're signing leases, they're not really thinking about the exit clause, but it's important to kind of consider what would happen if you wanted to either sell or assign your business to somebody else. If you go to sell your business, the lease must be assigned to the new business owner. And so you want to make sure that that is going to be as simple as possible when the time comes. You can't negotiate it after the fact. It's very, very difficult to get the landlord on board after the fact. So a couple things you want to look at is there a cost of assignment? A lot of times the landlord will have a fee to assign the lease to the new party. And that's because they have to review the new tenant. They have to see if they're eligible, whether their financials are good. And they're taking a risk on because you're a known risk at that point, but now they have to assess somebody else to see if they're going to be a good fit for this lease. So there is usually some kind of assignment fee. So you want to try to negotiate that down as much as you can. There's also going to be certain language in the assignment clause. That one example is a landlord may say that in order for you to assign a lease, it has to be with their approval, but in their sole discretion. So that means that if the landlord doesn't like you or your potential buyer doesn't like the color of their jeans that day or doesn't like, anything, they can just flatly deny you the assignment. And that essentially means you can't sell your business if the landlord doesn't approve the assignment, because the party that's going to buy it has no right to the space. So the other thing, the better language that we usually try to negotiate is to say in their reasonable discretion. It's kind of a gray area, but it gives you some right to argue with the landlord to say, hey, landlord, give me a real reason as to why you're denying my request for assignment here. If the person that you're trying to sell to, if they have good credentials, good financials, they've had some experience, then it's much more difficult for the landlord to deny them an assignment of your existing lease. And so this is really important if you want to capture the value of your business on your sale. Because if you can't sell your business and your lease term is close to being done, or you can't operate anymore, then you have no way to recover what you put your hard work and sweat into your business. You'd have to just shut down. So being able to sell your business is extremely important, but the assignment part is extremely important with it, because without that, you can't sell your business. Then the question of guarantors. So in most leases, the landlord will require a guarantor. And that's because the company in which you are running your business may be brand new. The only asset may be that particular business that you're running. And the landlord doesn't want to take a risk as far as who to collect from if you default on the lease. If you shut down, who are they going to collect from? So oftentimes the landlord will ask for a guarantee. It could be from you personally, it could be from you and your spouse. They could even ask for all the business owners, all the members of your LLC or all the shareholders in your corporation. It just depends on how much security the landlord wants. So you can definitely try to limit it as much as possible, but it is something that you should consider when signing a lease, that it will most likely be required. One thing to try to negotiate on guarantees is that in the event of an assignment, so if, for example, you sell your business or you sell the shares in your business, if there's an assignment, you should try to negotiate up front that the guarantors would be released at that point. Again, not something that the landlord will usually agree to, but something that you can definitely try to negotiate up front. So that's the gist of our lease presentation. There's certainly lots and lots of more areas of leases that can be discussed and are open for negotiation. So the next time somebody tells you that you cannot negotiate a lease, prove them wrong, because there's lots of areas that you can review and negotiate with the landlord. The first step, of course, is to read your lease, because remember, once you sign it, there's nothing anybody can do to really change it. Nobody has any incentive to adjust the lease terms after the fact. So if you were to hire an attorney, definitely bring them a lease copy before you sign it, and then have them possibly help you negotiate with the landlord. Oftentimes your steps would be to talk to a leasing agent or maybe the landlord directly and kind of lay out the things that you want. So of course, on your end, you should talk about, the rent structure, the pricing. You can talk about things you should be clear as to whose responsibility it is to maintain insurance on the property, whose responsibility it is to pay for the taxes. These are all separate subjects too, because there's lots of information on all of these that is important to know. But for example, for insurance, there is the insurance that is on your particular business, like the inside of your business, and then also liability. So if there was a fire and everything burned down, the landlord is typically responsible for rebuilding the shell, but then that's it. They would just hand it over to you as a vanilla box. And then everything inside would be your responsibility to fill in and restock inventory and all that. And that's where insurance comes in. They would pay for that whole cost to do that, to get you up and running. A lot of times insurance will also pay for your business loss, for the time it takes for the building of the premises to get it up to speed, to get it ready with inventory until you're able to actually open up for business again. So insurance is extremely important. And then there's a property insurance, but sometimes the landlords will have the tenant reimburse them for. So those are important things to check on the lease as well. And then with taxes, the same thing is true. There is the personal property tax. So personal property means your inventory, your equipment, everything that's within the four walls of your space typically. And you're going to be paying, it's usually a smaller tax from the county or from the city that you would be paying. And then there's the property tax for the overall building and land that gets paid to the county and the city again. But again, it's important to know whose responsibility it is to make those payments. The other big thing that tenants should look at in the lease is going to be about repairs. And oftentimes people just glaze right over this section, but it's extremely important because eventually something is going to break or it's going to need maintenance. Some of the big items are HVAC, plumbing, electrical, structural issues, outside maintenance, whether there's going to be some common areas that the landlord will take care of, or everything is your responsibility, and to what degree. And all those things can be negotiated. Even things like HVAC, you can negotiate where you're only responsible for up to a certain amount of money for maintenance or for per incident, and then anything above that cost would be the landlord's responsibility. So there's lots of creative ways to kind of limit your liability and try your best to assess what your monthly and annual expenditure is going to be with respect to the lease. But not reading the lease is probably the worst thing you could do. And then if you do read it but don't understand it and don't bother asking about it, that's probably the second worst thing you can do. So not knowing the lease provisions or not understanding it is not really a defense anywhere. And if you ever got in a situation where you were being evicted and you failed to pay something, you failed to do something, the judge is never going to take, well, I didn't know that was my responsibility as an excuse. And so it's extremely important to review these things ahead of time, ask for help. There's lots of places you can get help in understanding what the lease provisions say. And that brings me to our free consultations we have with the trusted lawyers and the CNPP SBA Community Navigator project. So please either click on the QR code or click the link to see how you can sign up for a free consultation. Thank you so much for joining.